Hello everyone and welcome to Daily Newspaper Analysis, which is brought to you by LawSikho. Really sorry for the delay, guys. There were some limitations and that is why the TNA, this newspaper analysis basically is coming a little late to you. Let's see. And today you will have to hold in patience. It might be a little longer than our usual newspaper analysis because we have three editorials, three articles that we have taken today, but all of them are very interesting and they are really, they talk about very important questions of law. The first one is from the Hindu newspaper, which has been taken the article is still a long way for termination as an unconditional right. This talks about the unconditional right to abortion that a woman must have. It has been debated so in the article, and it talks about the medical termination of the Pregnancy Act. Let's see what all we'll discuss in detail. Secondly, we have this article from the Indian Express, which is titled as Sedition Law, History Debate. Now, as we know that sedition law again has been into news, but now for really good reasons, because now it is being considered to be struck off, to be taken off, and to be made unconstitutional. But what are the problems that are we are facing across, and what actually is this will be discussed in this article. Thirdly, we have another article from Indian Express itself, and the title is Exception to Marital Rape. So all of these things that we'll be discussing today are something that are hot topics of law. So let's all hold in patience, and we hope you're going to like this session. Fourthly, we have the news updates for important awards, appointments, and events. And fifthly, we have the legal news covering up the most important case laws for the day. Also, guys, if you like this discussion, do give it a thumbs up and do not forget to subscribe to our channel. And before we move further, I would like to congratulate the students who gave the right answer in the previous newspaper analysis. So I'd like to congratulate Ankita Maji, Sudipti Mukhopadhyay, Hiba Shahid, Ankita Thapa, Kanika Sharma, Kunal, Paras Ahuja, Megha, Badal, and Shivani Dinkar. So awesome, guys. You have all given the right answer. And today also, I'm hoping that the question that I'll be asking, you'll give the right answer as well. Also, before we move further, here is a very important announcement that I would like to make is about the daily TNA quiz. Now, TNA basically gives the thorough newspaper analysis that we are just right now listening to. So I'd like to inform you all that based on this newspaper analysis, every morning we have a daily quiz. It is at 8 a.m. in the morning. It is a Google form quiz and the link is shared on the Telegram. So if at all you are a student who is there a part of LawSikho, so you already will have the access to the link through your WhatsApp groups. If at all any one of you is watching just through YouTube, please guys, you can join a Telegram channel. The link is there in the description box below. And you can participate in this quiz every morning at 8 a.m. The Google form access is open till 11 a.m. I'll tell you that, guys, more than 200 students are participating in this quiz every day, and it is a revision method for this particular newspaper analysis. So we hope that you're going to like it. So do definitely be a part of our Telegram channel and participate in the quiz at 8 a.m. It will be accessible till 11 a.m. It will not take more than 2 minutes for you to take the quiz, and we are very, very sure that it will help you a lot for the revision as well. Also, if you wish to download the PDF of the slides, then also you can join the same Telegram channel. The PDF will also be circulated there itself. On this note, guys, let's quickly start with the discussion for the day. When we talk about that still we have a long way for termination as an unconditional right. So the IPC, that is the Indian Penal Code, holds that a woman who caused a miscarriage is an offender. Now, here is a question for you guys, that can you look out in the Indian Penal Code and tell me in the comment section that which particular section of the IPC talks about this provision, that if at all a woman knowingly causes a miscarriage, then she will be proclaimed as an offender. So this article says that if someone was liable for the same shall be deemed as an offender unless it was done in good faith to save the life of the mother, generally when we get the abortions done. Now let's consider that the Medical Termination of Pregnancy Act has been amended twice, and the recent one has been amended just in 2021. If you remember, guys, that this was again into a bit of controversy, wherein when we talked about the medical termination of pregnancy, there was again a question of bodily integrity, the bodily autonomy, and we'll be discussing this further as well. So, however, the same does not recognize the right of the mother to decide with the continuance of the pregnancy. Please consider that here we're talking about her absolute or unconditional right to decide as to whether she will be carrying the child or not. Only in the given situations, only in some particular situations that might be life-threatening, she is allowed to abort the child, otherwise not, which is again a question on privacy, on bodily autonomy as well. So the medical termination of pregnancy aims at children born out of rape, or when contraception has failed. That means it was an unplanned pregnancy. Further, it also applies to when the child born may be physically or mentally challenged. So these are three conditions precisely that we can say are mentioned under the Medical Termination of Pregnancy Act when the abortion is legally allowed. Firstly is that if the child is being born out of rape. Secondly, if the contraception that they might be taking up has failed. Or thirdly, that there is a chance that the child who would be born may be physically or mentally challenged. Now, another issue of with the pregnancy is the gestation period of 20 to 24 weeks, which means that here you'll have to actually wait only till this period the pregnancy or the abortion will be allowed, while the range requires the approval of a medical practitioner, and anything more than 24 weeks will actually require the examination and approval of a medical board set up by the state. So definitely you can see here that the process is way too cumbersome, and many a times such delays ultimately result in the abridgment of a right of a woman to get the child aborted. Now, the issue lies here in the fact that the courts have held countless times that the decision regarding the continuance of pregnancy is akin to right to life, and hence it is non-negotiable. Also, guys, if you can tell me that which article of the Indian Constitution deals with rights to life and personal liberty. Next, it says that the decision of the mother regarding her pregnancy has also been linked to rights to privacy by the Supreme Court. Now, if at all amongst all these questions, if you could also tell me that in which important judgment was right to privacy hailed as a right, being a fundamental right under Article 21 of the Indian Constitution, please pause this video right now, just go to the comment section and let me know the name of this case. Now, the standards that have been set out in these judgments have not been incorporated into the amendment. Of course, that is very much evident. And thus, while this country has witnessed the right to terminate pregnancy, now what we right now also need is the right to foster. The unconditional right to abort the child should also be available to the women. Let's hope that in the coming future, with further amendments, hopefully, that this right also will be given to the women. Secondly, sedition law, history and debate. So 6 decades after the Supreme Court held that sedition law was unconstitutional, the same is again in the court of law where the apex court will decide on it. So the Supreme Court kept the provision in the abeyance until the government of India had finished re-examining the provision. So we can say that it must be one of the most long awaited things that we all were looking forward, that sedition law was way too colonial in its nature. And when here, when we talk about the freedom of speech and expression being a fundamental right, sedition was something that was completely curtailing this fundamental right. We have knowingly not mentioned the section of Indian Penal Code which deals with sedition, because guys, I would like you to brainstorm and let us know that which section of the Indian Penal Code talks about sedition. We covered this a day or two ago, so I hope you all know about it. So the sedition law was brought into the Indian Penal Code in 1890, while the life imprisonment for the same was inserted into 1955. So please note, guys, that the Indian Penal Code in itself is it was brought in the year 1860, but the sedition as a provision was added in the year 1890. Also, here is a fun fact for you guys, that at the time of 1860, when the Indian Penal Code was actually brought, the Viceroy of India was Lord Canning. So this is it is a brownie point for you. So please, you can note it down, or just you can recall this. So the provision was used to curb political dissent, and complaints were lodged against Bal Gangadhar Tilak, Annie Besant, Muhammad Ali, Gandhi, and others in the name of sedition, because of course they were raising voice against the colonial rule. Now, several members disagreed on including sedition as grounds of exception of fundamental rights in the Constitution as well during the time of Constitutional Assembly debates, but ultimately it was made a part of the Indian criminal system. Next, when we talk about the sedition law in India, there are various case laws, and very important ones though that have talked about sedition. So in the case of Ramesh Thapar versus State of Madras in 1950, it was held that mere criticism of the state or the government exciting bad feeling against it could not be held as sedition. So we have the right basically to talk about the government, and if it is fair criticism, then it will not amount to sedition. Next, in the case of Tara Singh Gopi Chand versus the state, the Punjab and Haryana High Court held that sedition was unconstitutional and was a colonial rule to curb the dissent. Again, in Kedarnath ruling, it was held that sedition charges can only and only be invoked if the dissent was a call for violence. And if such violence does not take place, then any act of that person will not be amounted as sedition. So similar observations were also held in the case of Balwant Singh. So all of these cases have time and again said that sedition is unconstitutional, and it is definitely not in the spirit of freedom of speech and expression. So United Kingdom, Australia, and Singapore have all removed the provision from their laws and have called it arcane. And surprisingly, guys, United Kingdom that had brought this provision for India has itself now removed it, but in India we still haven't done so. Same was the case with adultery as well. Now, only United States considers it yet as a federal felony. Now let's discuss the third and the last article for the day, which talks about the exception to marital rape. So Delhi High Court has delivered a split judgment on the constitutionality of the marital rape, and the same is now to be referred to a bench of 3 judges. As we know now, guys, that many are coming forward and saying that marital rape as an exception to the definition of rape under the Indian Penal Code should not be considered anymore, and it should also be considered as a form of rape. So the country is already rife with Section 375 of the Indian Penal Code, which actually describes or defines the rape, which states that the act of sex by a husband with an unwilling wife cannot be termed as rape. I know, of course, that when we again talk about the bodily integrity, the consent and everything, this comes out to be as a surprise that a marital rape in India is still not considered to be as an offense. So the debate till date, which has protected this exception, spans around that protecting men from the misuse of this law and from protecting the institution of marriage. So of course, there are 2 reasons. So protecting men would be that maybe if it is made as an offense, so every now and then false and malicious prosecutions would take place against the men, wherein women would threaten the husbands of, dragging them into a particular trial in the name of marital rape. And secondly, of course, protecting the institution of marriage. Well, this is, I don't know how it comes as a protection of the institution of marriage. I suppose that if at all a person or, one partner has to force another partner into, get into such an intimate act. So I think the institution of marriage has already failed. But of course, there are different contentions to it. Let me know, guys, what do you think about it? So since the verdict is split, the Delhi High Court has granted a certificate for the referral of the matter to the Supreme Court. And now let's see what Supreme Court will decide to it. Now, even though the judgment is split, the intervention is a favorable ground for doing away with this exception. So of course, this in itself is a point of celebration that we are at least considering making marital rape as one of the offenses. So the Karnataka High Court on a similar case charged the accused with unnatural offenses, criminal intimidation, domestic cruelty, and assault. So that was a step in the right direction. And the immunity of marital rape is present in various common law countries, and the same has been struck down. Please consider that these countries have struck down marital rape in, as a protection or as an immune thing. So it is in the countries of Australia, Canada, South Africa, and United Kingdom. With this, let's begin with the news updates for the day. Firstly, B.V. Doshi receives the Royal Gold Medal. So, a well-known Indian architect Balakrishna Doshi, who is credited with designing some of the most iconic structures in the country, was conferred with the prestigious Royal Gold Medal 2022. Which is one of the world's highest honors for architecture. So here, the most important thing for you to remember that the Royal Gold Medal Prize or award is associated with what? So you should remember that it is associated with architecture. Secondly, Rudrankksh Patil bags gold in all Indian men's air rifle final in Germany. So it is a proud moment for India, wherein Rudrankksh Patil won a gold medal in men's 10-meter air rifle event at the ISSF Junior World Cup in Seoul, Germany. Thirdly, Utkarsh Samaroh. So Prime Minister will virtually address a gathering called as the Utkarsh Samaroh in Gujarat's Bharuch today. So the program will mark the celebration of 100% coverage of 4 key schemes of the state government in the district. Now, these 4 key schemes have helped in providing timely financial assistance to those in need. Fourthly, 10th India-Oman Joint Commission meeting. So the 10th session of the India-Oman Joint Commission meeting was held on 11th May 2022 in New Delhi. It was co-chaired by Shri Piyush Goyal, Union Minister of Commerce and Industry, Consumers Affairs, Food and Public Distribution and Textiles, Government of India, and the High Command. Fifthly, India unanimously elected as a new chair of the Association of Asian Election Authorities for the term of 2022 to 24. So India has been unanimously elected as the new chair of the AAEA, which is the Association for Asian Election Authorities. So the meeting was recently held of the Executive Board and General Assembly in Manila, which is the capital of Philippines. This was all for the day. We hope you liked the session. Today we did not have any particular case law, so that is why we did not include any such into it. And do give a thumbs up, guys, if you liked it. Be a participant of a Telegram channel and take the quiz tomorrow. And also you can join the channel for our PDF for the slides as well. Thank you so much.